So, if you guys don't think that you are dealing with the most corrupt scumbaggery scumbags in the world, if you think for 1 second that the attorneys, the liars, the lawyers that are protecting their so-called assets aren't going to do everything in their power to throw a curveball and then act like they're innocent. So I need to give you guys an update on my case. Again, this is all just documentation. I'm not a lawyer, all that shit. So uh, the other day, I got an email, and it's from Pacer. This is public access court electronic records. Okay. I set up an account because I was downloading all of my court paperwork that they entered and checking the docket. And if you guys remember, I put in a motion for summary judgment because I didn't get anything in the mail and I assumed that they defaulted. So I got this the other day while I was kicking back. This is 8 days ago. So this was what was that, last Thursday, Friday? So let me show you what's going on here. So I got, just a little email popped up. So I open it up and it says you have zero balance. And right here it says log in, manage your account. And I thought, you know, maybe I'll just go in there and look around. So we logged in and we looked for Douglas Dmoomey. And there's my case number. And there's Office of Recovery Services. And then we went in and pulled up the docket. And this is what this looks like. And what do you know? Here's the complaint. Here's the motion for extension of time. Okay. There's the order granting the motion for extension of time. And then there's a notice here that it's being assigned to a judge. And if you remember, we did the consent form, right? And I said, I don't want a magistrate looking at my case. I want a judge. So the consent forms have now been received. And look at that. On 9/25, he put in a motion to dismiss. And I still, to this day, have not received anything in the mail, which would explain on 10/1 my motion for summary judgment. And then he put in a memorandum in opposition of my motion for summary judgment. And this isn't going to make any sense because the motion for summary judgment is going to say, well, he didn't respond, so he's in default. So this memorandum says basically that. He doesn't know what I'm talking about. It's a bunch of crap. You got to dismiss it. It's failure to state a claim. It's not federal jurisdiction. It's state. The state has, the state has immunity, all this other stuff. So I put in a response to the motion to dismiss, and I filed that, and I've been working on that. Just been working a lot and trying to get this stuff in. So, and here's another thing that's in here. There's an order referring the case to a magistrate. So, what the fuck? Didn't I just say right here on 9/24 that I did not consent to having a magistrate look at this case? It says case randomly assigned to Judge D. Benson. So I don't understand. So anyway, that is what's going on with the case. They filed a motion to dismiss, and I have not received that to this date. This is 9/25. He was supposed to mail that to me, and I still have not got it in the mail. And let's just look at the address. There's the address. That is my address. Okay. You guys have seen that on 100 documents. It's right there. So where the fuck is it? Well, here's the other thing. He also put in a memorandum opposing the motion for summary judgment, and I still haven't got that 10 days later. So what the hell is going on, dude? So I got, I got a certain amount of serenity and a certain amount of integrity. And so let's, the first thing I want to say is you'll notice that it says response. Okay. It does not say motion to dismiss for failure or motion to whatever, because that's an argument. Okay. It's a response to a motion. It's not a memorandum opposing. Okay. Remember, opposition gives the court something to argue. Okay. So let's look at what we did. So a couple days ago, this got mailed. So let's read what we said. This is my response to the motion to dismiss and judicial notice. And I tried to explain, well, let's just read it. So the plaintiff's authorized representative, okay, remember that's not you. You are the representative of the all cap name. Notices the court that plaintiff has not received a copy of any motions in the mail from the defendant and pleads flexibility of this court for an extension of time to respond to questionable practices of the defendant. These motherfuckers are so corrupt. The required 14 days should be enlarged to 21 to enter evidence of insufficient service by defendant. Plaintiff requests this court to address the facts of this case and not focus primarily on procedural deficiencies, but on the sufficiency of the pleadings. Okay. In other words, let's look at the facts. Okay. Let's not get all, let's not get our panties in a wad because of, some kind of procedure. Okay. Because we all know I'm coming in pro se. So here's the affidavit again. I always put in affidavits because affidavits stand as truth. The plaintiff filed a motion for summary judgment on October 2nd because no mail had been received from the defendant, and the assumption of default was the basis for said motion. The motion for summary judgment from the plaintiff clearly shows a presumption that no motions had been filed, and plaintiff asked for judgment based on the assumption that defendant had defaulted. Okay, that would be, well, we're going to read it. This court can also plainly see by reading the motion, that's the motion for summary judgment, that the plaintiff received the motion for an enlargement of time from the court, which I got, but for some strange reason, no other mail has been received from the defendant. This is a fact and is evidenced by an affidavit signed by a witness. Okay? And I've got a witness and an affidavit of no mail. So on October 13th, the plaintiff's representative was writing the proposed order and noticed an email from Pacer. You guys remember me writing the notice of the proposed order, right? That was on Saturday. I was in a good mood. Everything looks good, right? We still haven't heard from anybody. So here it is. And noticed an email from Pacer, the online case lookup. Plaintiff has waited patiently for weeks to receive the inevitable motion to dismiss from the defendant, but had not received anything in the mail. Please see affidavit of no mail below, signed by a third-party witness. This is the reason the plaintiff moved forward with the summary judgment, and this would explain the language of said motions. Okay? You guys remember the motion for summary judgment was a half a page. Okay? They failed, their default, give me my money, right? Well, if they filed it electronically with the court, but they never sent me the documents, then I would go into default. See, they are so crooked, man. They are so corrupt. After logging on to Pacer, plaintiff's representative became aware that the Attorney General's office had filed a motion, but they did not send a copy to the plaintiff. As of today, plaintiff has still not received a hard copy of the motion or a hard copy of the opposition, which is questionable because they filed electronically with the court. The only way the plaintiff became aware of the filings was an unintentional email from Pacer, which upon investigation proved that motions had been filed without the plaintiff's knowledge. The defendant has no evidence of actual mailing, okay? And this is going to be important because no documents are signed, no certified mails receipts have been entered proving mailing, right? Proving service, and an unsigned third-party certificate of mailing is an assumption of mailing, not actual proof of mailing, okay? Now that's a fact, and we all know that. I've sent all my shit certified, right? This presumption of mailing has now been rebutted. This court must find that service is insufficient or at the very least questionable, grant the plaintiff time to respond, and this court, see, not time to argue, okay, just want to respond, and this court should deny all motions that are not signed under commercial liability, right? That's another fact. They're not signing anything. Nobody's taking liability, okay? So that's something else you always want to bring up, man. Okay, so here's my response. Defendant's motion to dismiss is predictable. Counsel goes on and on about immunity and jurisdiction, but doesn't address the fact that this case has already been decided. Contract makes the law. Failure to respond creates default and estoppel. This court must rule that the administrative process between ORS and the plaintiff is valid and has created an estoppel against defendant from any further collection or enforcement. ORS had a duty to respond, and in their arrogance or ignorance, decided not to respond to a lawful, not legal, lawful attempt to provide an alleged debtor proof of claim, right? Through tacit procuration and silent acquiescence, ORS has agreed to the terms of the administrative process. That's a fact, okay? Now, they could argue that, but I'm not here to argue, right? Defendant does not have 11th immunity, okay? That's part of the thing they put in their motion to dismiss because they think that a legal fiction that doesn't exist, they think that a legal fiction, because they wrote something down on a piece of paper in a regulation or a code somewhere, gives the state sovereign immunity, okay? Well, if you guys were back a couple of, I don't know, 3, 4, 5, I guess, before contracts, we talked about the Clearfield Doctrine, okay? And the Clearfield Doctrine clearly says that where Federal Reserve notes are concerned, governments descend to a mere private corporation and they lose immunity, okay? So they're not a government entity. They're not a government agency. They are a private corporation and they are not immune, okay? Even the federal government and the state of Utah are corporations. ORS operates in commerce and contract law applies, okay? ORS is enforcing federal child support enforcement law, 42 U.S.C., Title 4D of the Social Security Act, also seen in the Federal Manual of Child Support. Defendant omits the fact that ORS receives federal grant money for welfare expenditures, extra incentives for divorces, and he also admits the fact that the state of Utah, all capitalized, right? Remember that? It's all capitalized. What does that mean when it's all capitalized? Is not a party to this action, okay? We're not talking to the state of Utah. We're talking to ORS. ORS is the party. And while being administered by state actors, ORS is federally funded, and ORS uses the Social Security number for services, right? What's the Social Security number? Yeah, we all know what that is. If you provide a service, there must be a contract for services. Federal jurisdiction applies to this case because it deals with commerce. Okay? Counsel for defendant also admits the fact that court sent the summons, and the summons from plaintiff was just an extra copy sent by the plaintiff. Okay, let me explain that real quick. So, failure to state a claim upon which relief can be granted, and then he tried to stick in some 12B6 or something, F4B27 LBGTQPIA, to the 10th power stuff about insufficient process. Well, that's because, and again, if you guys remember, I sent them a copy and the court sent them a copy. So, what does it say here? Counsel for defendant admits that the court sent the summons, and the summons from the plaintiff was just an extra copy sent by the plaintiff. Either way, defendant received the summons from the court, and this is more misdirection. And writing statutes and codes meant to protect ORS and the state from lawsuits by circumventing due process are void. ORS is not sovereign. ORS is responsible for the actions taken by their employees. Okay? Counsel for defendant also admits the fact that relief is spelled out clearly. Relief can be granted by this court by reviewing the administrative process. Okay? That's all I want. Unless the defendant rebuts these facts, they stand as truth. Okay, here's my summary. This case has already been decided. Only asking for, for the court to review my process. The plaintiff will not participate in public displays and will not be coerced into arguing with defendant's counsel. ORS is already in default. There's nothing more than an attempt to dismiss before the court decides plaintiff has a valid claim. Service of process from defendant should be sent certified mail and signed. Any attempts to default the plaintiff again should be seen as contempt, and this deceptive, outrageous, unethical, immoral practice, if true, should be met with swift sanctions. Plaintiff has shown evidence of a valid address and demands that all communication the defendant has with the court be sent to the plaintiff without exception. Okay? And then here's my affidavit of mailing, right? This is the girlfriend. She's going to sign there that says, I witnessed the plaintiff representative check the mail every day, right, at the address, the Hillside Apartments, blah, 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 since the initial filing of the lawsuit. And I affirm that no mail from the Attorney General's office has been delivered regarding this lawsuit. Okay? I'm a resident of the same apartment number, and I swear they have not received the motion to dismiss to date. Right? And then you got your certificate of service. Okay? So that's what's going on. I got some other stuff I want to share with you guys, but this one's getting kind of long. So we'll see what happens. Peace.